Hello, Rabbi.
Good afternoon.
How are you doing, Rabbi?
Thank God, and you, Kent?
All good, thank you.
Hope the weather in Cape Town is better than here. Hasn't stopped raining for a week.
We could do with some rain, but no, it's actually quite a nice day. A little bit overcast, but still a lovely day.
Our gardens are very green, but the rain hasn't stopped. Give me 1 minute, I'll be right back and we'll start.
Hello, Dennis. Hello, Stephen.
Hello.
Mark.
Hi, how's it?
All good, thanks.
Hi, everyone.
Hello. Hello, Rabbi. Hello.
Hello, Stephen.
Hi, guys.
Hello.
Okay. Is it 1 o'clock yet?
Indeed.
Hello, everybody. Are we ready to roll?
Hi, Rabbi.
Hello, Rabbi.
Okay, so we don't have slaves today. We are all enslaved by a crazy society. But in the olden days, they had slaves, and they were vassals. They were pretty much owned by the people. And today we're discussing how to free a slave. So if you want to give him or her their freedom, there's a way to do it. And some ways work and some ways don't. So it's a short chapter and pretty straightforward. And we'll learn that in certain ways, freeing a slave, the legalities parallel freeing a woman, your wife, from marriage. So the laws of divorce and the laws of freeing a slave have some similarities. There are many laws that are not similar at all, but some are similar. So, Aleph, hakosev get shichur la'avdei. When a person composes a bill of release for a slave, a document, so you give the guy a document that you are hereby freed, then that works. Like a get, there's a document that you give your wife to divorce her. So if he composes a bill of release, but then he doesn't give it to the slave, here we have some complications. He gives it to someone else to acquire on the slave's behalf. And the language is important. What does he say? He says, take possession of this bill of release for so-and-so, my slave. Then the slave is granted his freedom, even though the bill of release did not reach his hand. So he's saying to this agent, you take possession of this bill of release for my slave. So as soon as he receives it, the agent, the slave is already freed, even though he didn't get the bill of release. Because it's possible to acquire something of benefit to a person outside his presence. If, however, he said, give this bill of release to my slave, he didn't say you accept it on his behalf. He said, I'm just making you an agent, an emissary, an Uber driver or a courier to deliver this bill of release to my slave. So he says, give this bill of release to my slave. So number one, the owner may not retract, can't change his mind. However, the slave does not attain his freedom until the bill of release reaches his hand. Because what was the language of the master? Give this bill of release to my slave. He didn't say accept this on behalf of my slave like in the previous case. He said give this to him. So until he gives it to him, he's not free. Therefore, if he says, give this bill as my slave, and then he dies before the slave got it, it should not be given to him after his master's death, and he's unfortunately not free. Now, when a person composes a legal document saying, I made my slave so-and-so, that's his name, a free man. Or my servant so-and-so was made a free man. Or he is a free man. All of these different languages and texts are kosher, and he is duly released. If the document, however, states, I will, in the future, I will make him a free man, he's not released until he does so. 3, when a master states that he released a slave and the slave denies being released, stupid slave, if you ask me, could have had his freedom. He goes and argues. The master says, I made him free. And he says, no, you didn't. Don't you want to go free? Just say yes. But he says no. So we suspect that the master had another person acquired to be released on behalf of the slave. So maybe he gave it to someone else to give to him, but he never got it. So he's not free yet. If the master said, I composed a deed of release and gave it to the slave, and the slave says, you neither wrote it nor gave it to me, the statement of a principal, this slave is a principal in this case, is considered as equivalent to the testimony of 100 witnesses. And he'll still be a slave until he's freed in the presence of witnesses. So he didn't, the guy says, I made you free, and he says, no, you never wrote it, you never gave it to me. So we need to find other proof that the situation has changed. Now, number 4, when a person commands at the time of his death, my heirs should not subjugate so-and-so, my maidservant. Okay? Gladys, my maidservant, has been very nice to me. My dying wish is that you should not subjugate her. Now, what does that mean? Does that mean you freed her from slavery? Not quite. What it means is she is still considered a maidservant as before, but it is forbidden for his heir or heirs to subjugate her. For it is a mitzvah to fulfill the words of a deceased person. So they can't use her as a slave. She's still a slave in her status, but they cannot use her in any in the fashion that one would normally use a slave. Similarly, if a dying man says, generate satisfaction to so-and-so, my maidservant, be nice to her, in other words. It doesn't specify what it is, it just says be nice to her, make her feel good. We compel the heirs not to make her perform any tasks other than the ones that she desires to perform. If she's happy to do something, fine. Anything she's not happy to do, may not do because he said, keep her happy. If he commanded them to free her, then we compel the heirs to free her. 5. Now he lists a number of items where we have halachic similarities between a get, giving a bill of divorce to your wife, and giving a bill of freedom, of release to a slave. In both cases, we are releasing the other person from their status. So there are 6 matters in which a bill of release given to a servant is equal to a bill of divorce. When it comes to other matters, a bill of release is equivalent to any other legal document, like a business deal or something. What are the 6 in which it's comparable to a divorce? A, they are not acceptable if prepared by Gentile legal authorities. A get has to be prepared by a Jewish Beth Din, not by a secular court. 2, they are acceptable if one witness is a kuti. You know what a kuti is? Have you had this before? Kusi or kuti. So it refers to the Samaritans, Gentiles who were brought by the king of Assyria to live in Israel after the 10 tribes were exiled. So we're talking about a long time ago. Then this tribe of non-Jews converted to Judaism. However, they were not so careful in their observance, and therefore they were considered like semi-Jews, pseudo-Jews. And later on in history, they were found to be completely unobservant and unbelieving in our faith, and they were deemed to be the same as non-Jews. But there was a time when they were considered sort of pseudo-Jews, and you could have used them as a witness. So both a divorce and a bill of release for a slave would be acceptable in those days, once upon a time, before they were made to have the same status as non-Jews. They could be an acceptable witness. C, they must be written for the sake of the slave was being freed. So it can't just be a general document. Like a get has to have the exact proper Hebrew names or any name by which the person, the woman, is known by. So too, the document here has to be written for this slave personally. D, they may not be written on an article that is attached to the ground. We'll learn a little later in this chapter, it says that you write a get and you give it to your wife. So we learn from this that when you give it to her, it has to be ready for giving. If you have to first detach it, let's say you wrote it on a big leaf or on a branch, you engraved it in a branch from a tree, and then you had to still break off the branch or break off the leaf, it's not kosher. So you have to break off the branch or break off the leaf before and then write it. So as soon as you've written it, all you have to do is give it to her and she becomes divorced. Likewise with a bill of release for a slave. E, the witnesses may sign only in the presence of each other. And finally, number 6, the same laws apply to a bill of divorce and a bill of release with regard to bringing these legal documents from one place to another. We'll explain soon what that means. So number 6 is going to explain this. All legal documents that are composed by Gentile legal authorities are acceptable, provided they conform to the conditions of halacha, with the exception of bills of divorce for women and bills of release for slaves. So whereas a document, a secular document written up in a non-Jewish court, let's say that Reuven owes Shimon 1,000 rand, that's a legal document which will be accepted in Jewish law. There's nothing wrong with that. But a secular non-Jewish court cannot write a get for a woman or a bill of release for a slave. Any legal document that is signed by even one witness who is a kuti is not acceptable, with the exception of bills of divorce for women and bills of release for slaves, provided the kuti is known to be precise in his observance. This is, as I say, once upon a time, before they were seen to be non-observant, and they were banned and they were made the equivalent of non-Jews. In the present age, when the kutim are considered as Gentiles with regard to all matters, as I said, we would apply the law stated with regard to the kutis to another group called the Sadducees, or in Hebrew, the Tzdoikim. You know what the Tzdoikim were? What was their style? Anybody know? Sadducees?
They didn't accept the oral law.
Correct. Thank you, Kent. They only accepted the written law, the Chumash, the Tanakh. They did not accept the oral tradition, meaning the Talmud and rabbinic law. So the Sadducees would, in a sense, replace the Kutim, that they could be relied for some things, but not for most. Now, with regard to a woman's bill of divorce, it states, Torah states, the Chosav law, he should write it to her. And from this we mean law that has to be lishma, for her sake. It has to be her name. It has to be personalized. Every get document has to be very personal. A Beth Din today that performs a get will go to great lengths to make sure they get the names 100% correct. You know, today when most people go by their English name, a get will have the Hebrew name and the English name. There's no confusion whatsoever about who the person is. So it would, let's say Chana, the woman, her Hebrew name is Chana, and they call her Kathy, yeah, or Anna. Often the Chana became Anna. So the Beth Din would instruct the scribe who writes the get to write Chana, who is known as Anna, the daughter of Chaim or whatever his name is, who was known as Henry. So we want to make 100% sure that it's personalized and it's not confused with anybody else. So here too, it has to be written for her sake, and likewise with a bill of freedom, of release given to a slave, whether it's a male slave or a Canaanite maid servant, a female slave. It says, nor was freedom given to her. It teaches that the bill of release must be written for her sake. It says law, not some law for her. So we see that this too, like a get, has to be written for her. So it has to say her name. With regard to a woman's bill of divorce, it states, and he shall write and he shall give. The kosav v'nosan law. He should write and give it to her. So this is, as I said before, this is why you can't use something that was attached to a tree, for example, and then had to be detached after you wrote it. As soon as you write it, it has to be able to be given. So you have to detach it first before you write it. So because it says v'chosav and nosan, he shall write and he shall give, sages interpret that to mean that the bill of divorce should be given on a substance, that all that is lacking is that it should be handed over to be given, which would exclude a bill of divorce that is written while the article on which it is written is still attached. I gave an example of a branch of a tree or a big leaf from a tree, and afterwards detached. That's not going to be kosher because it is lacking both being detached and being given. It has to be lacking only just to be given once you've written it. If you still have to detach it, it's not kosher. Likewise, with a bill of release for a slave, where it says given to her, we learn that it also should be lacking only being given. So you may not write a bill of release for a slave on something that is attached to the tree or to whatever, or the ground or whatever else either. Witnesses may not sign bills of divorce for women and bills of release for slaves outside each other's presence. You need two witnesses. They have to sign in each other's presence. Now, 7. So we said that in 6 matters releasing slaves, the document, the laws are similar to divorce, and other things not. What is meant by the statement that the same laws apply to bills of divorce, bills with regard to bringing these legal documents from one place to another? We said that, and I said we would explain. So here he explains. What does it mean that a divorce and a bill of release for a slave, the halacha is the same with regard to bringing these legal documents from one place to another? So, when an agent brings a bill of release from one place to another within Eretz Yisrael, say from Tel Aviv to Jerusalem, he does not have to testify that it was written and signed in his presence. And in the diaspora, outside of Israel, if there are no witnesses present to verify the authenticity of the bill of release, and the agent states that it was written and signed in his presence, he was there, no problem, its authenticity is considered as verified. Afterwards, if the master comes and protests it, I never wrote that bill of release. It's a fraudulent document. It's a forgery. I never wrote it. I still want them to be my slave. If the master comes afterwards and protests, no attention is paid to him, as with regard to a bill of divorce. If we accept it, then it's done. The deal is done, and the guy is free. Just as when a woman brings her bill of divorce, she does not have to have the authenticity of the document verified. The bill of divorce is in her possession. She has the get. She has a document. She has legal proof. She doesn't have to call the witnesses who signed it. She's got the document. That's good enough. So too, when a servant's bill of release and is in his possession, he does not have to authenticate the document by calling the witnesses. Similarly, just as the woman must say, it was written and signed in my presence, when it was stipulated that she do so, as we have explained in that context, so too when a servant brings a bill of release and states it was written and signed in my presence, his word is accepted in the same way, just like the woman, and he does not have to have the authenticity of the document verified. Otherwise, there's no point in having a document. I need to bring two witnesses. What do I need a document for? Finally, number 8, everyone who is acceptable to bring a bill of divorce as a shliach, to be an agent, to bring a bill of divorce to a woman as the husband's agent, is also acceptable to bring a bill of release for a slave as the agent of the master. So, for example, you wouldn't use another slave and you wouldn't use a child under bar mitzvah, but any adult would be acceptable. A slave may receive a bill of release for another slave from that slave's master, but not from his own master. So let's say if there were 2 slaves owned by the same master, the master could not give a bill of release for a slave B and put it in the hands of slave A. That won't work. Why? Because everything that the slave owns, the master owns. So he's not giving him anything. It remains in his possession. So it's as if he gave him nothing. But if it's a different master, if the slave belongs to a different master, then that master can give it to this slave to give to his slave. I'll just read you a note here I found to explain that. The slave does not possess an independent financial capacity. When he accepts something, he is accepting it on behalf of his master. So when the slave receiving the bill of release belongs to another person, it is as if the bill were given to his master for the sake of that slave being freed. And that's acceptable, like we learned in the first halach of this chapter. But when the slave receiving the bill of release belongs to the same master as the slave being freed, the bill of release has never left his master's domain, and therefore the slave is not freed. You get that? Okay, let's finish. Final paragraph. When an owner writes a legal document. Okay, so now a Jewish man owns a Canaanite woman as a slave. Takes a fancy to her. She's not bad. She cooks pretty well. She's good looking, whatever. Wants to marry her. So he decides to give her her freedom and her betrothal at the same time. But he doesn't do it in the right way. So when an owner writes a legal document with which he seeks to consecrate, i.e. marry, his Canaanite maidservant, so first she has to be free and become Jewish for him to marry her. If she's a Canaanite non-Jewish slave, he may not marry her. Even though he tells her, attain your freedom by virtue of this document and become consecrated because of it. At the same time, this expression is not one that conveys freedom, and she is neither consecrated nor freed. So what we'll have to do is free her and then consecrate her. Okay, quick quiz. The person composed a legal document saying, I made my slave so-and-so a free man. Does the slave go free? Hello? Can't hear you.
Yes.
Yes or no? Anybody? Unmute yourselves.
Until it reaches his
Goes
hand.
free. Yes.
Can't hear you. What?
Yes.
Until it reaches his hand.
No. He
No,
goes
no,
free.
no, no, no.
Goes free immediately.
What?
The answer is yes, he goes free. We'll get to
Okay.
the reaching the hand now. If a person said, give this bill of release to my slave, to someone else, What is the law?
Number 3.
Number?
3.
Number
Yeah.
3. Number
Yes.
3.
3 is correct. Because he said, give it to him. So he won't become free until he gets it. Excuse me. So what does it mean? You should not subjugate my maidservant? Do the heirs have to free her? A, B, or C?
Number 3.
3.
Number 3 is correct.
Yeah.
She doesn't become free, but they may not force her to do anything she doesn't want to do. Do the witnesses who sign with the slave need to sign in each other's presence? Yes or no?
Yes.
Yes.
Very good. Well done, guys.
Thank you.
Okay,
Thank you,
so that
everyone.
was a quick share. We finished in 25 minutes. Thank you for
Thank
joining.
you.
Next week, I'm
Thanks,
in New
Rambam.
York, so I'm not getting up at 6 o'clock in the morning to give the share. So
Ah,
please forgive me, but I'm only away 1 week. So please God, the week after I'll be back.
Nasiya tova.
enjoy the
Enjoy.
kid.
Thank you. Thank you.
And then
You
I'll be with
too.
you till mid-December when I head off to Cape Town, please God.
Have a good
Okay.
kid.
Thank you.
Sei gesund, all the best.
Bye.
Thank you.
Bye.
Bye-bye.
Yeah.